The answer is already found. It's in page 173. You have multiplied it by 26, but then you divide it by 30. It will naturally be against the... Where is Mr. Dekar?
Look, he's having some back pain. He's not well. He's suffering from vertigo.
This is my pay for some time, Lordship.
Why 2 weeks time?
The officers are transferred, Lordship.
Can't help it. This cannot wait. Mr. S.S. Roy, Learned Counsel for the respondent railway, submits that he would require further 2 weeks time for placing on record the clarifications to the queries raised by this court on the last date of hearing. So prayer is not objected to by the Learned Counsel for the petitioner.
Because 2 weeks is too long.
So, in view of the above, the respondents are granted time till today is 31, 14/8/2025 to complete their instruction. Respondent counsel is granted time till 14/8/2025 to complete the instruction. Registry to list this matter again on 18/8/2025.
Let it be 19 or 20, Lordship.
19. Full stop. This matter would not be considered 19. This matter would not be considered any further as a part-heard matter, as a tied-up matter with this court, with this bench. The answer is already there. That day it did not come. You complete it by 26 and then you multiply it by 26. Then you should have multiplied by 30. If you have to have for the whole month, you multiply it by 30, divide it by 30, it comes to 655 only.
Lordship, we will satisfy if we divided, multiplied it by 26 and divided, we have the formula, Lordship, we will honor it.
Lordship, may keep it part-heard.
Lordship is heard.
I wouldn't know. It will be beyond that 1 month period. We'll not do it. If it comes back to me, nothing like it. I'll do it.
Lordship, may fix it in 7.
Today I spend a lot of time doing it, but anyway, no issue. Yes. Item number 15.
On behalf of the state.
You have already filed an affidavit.
We have filed our rejoinder day before yesterday, Lordship.
Not on record.
Not-
Not on record.
The matter will listed along with my affidavit, Lordship.
Why you want time? No, your affidavit is on record. Some 15 to some. You are appearing for whom?
On the state.
No, your affidavit in reply is not in place.
Next week along with my.
Mr. Bothagur, your this trace map at page 44, we can infer, but we would like to have a better, the colored portion or the colored filled up portion is the wherein you are doing the eviction right now. Page 44 of your Annexure B of your affidavit.
One part is, my lord, the patta land, the other part is the government land.
So this colored portion is the patta land. No, this is the, what do you call that? The eviction wherein the eviction is taking place.
Yes, my lord, that is where the eviction is taken.
And 978 is 978 and 974 are the pattas of the son and the father. That is the petitioners. So, madam, if you have land in 970 and 971, 99, you are liable to be evicted.
We have not, they have their.
Then we'll clarify that they will examine whether you are holding.
That can be done, Lordship.
be done.
We are not provided any chance to produce our document, our. case,
We
Lordship.
can dispose of this matter by saying that the district administration, before carrying out the eviction, shall ascertain whether the petitioner is occupying or encroaching upon any part of 970 Dag or 971 Dag.
But a chance may be given to us to represent lordship.
Deputy is also very much.
The affidavit is, the government affidavit is also very clear.
A chance may be given to us to produce our document to satisfy.
Government doc number 970 and 979. So yours is 978 and 974. It's totally different.
Yes, lordship, but lordship, they have served notice without hearing us, without
Fine.
giving us.
Fine.
At least one chance may be provided to us, lordship.
We'll allow them. Let the AG come. Before the additional AG, we will do that order, pass that order. It will be more effective. When?
Lordship.
Tuesday?
Tuesday also, my next.
Tuesday? Ms. Kanungo, Tuesday? As prayed for by the Learning Council for the parties, registry to list this matter again on 5/8/2024, 25. Full stop. The Learning Council for the petitioner has submitted that an affidavit in reply on behalf of the petitioner has been filed on
Day before yesterday, lordship, on
31, 30, 29.
29.
7/28, however, 25. However, the same is not on record. Registry to trace and tag the said records of the said AI affidavit in reply along with the records of this case on the next date of listing.
Interim order may be continued.
Interim order passed earlier to continue till the next date of listing.
Deeply obliged.
When the affidavit is very clear that you are not evicting the petitioner from her projected Miadi land, it's only 979 and 970. We will provide that if she is not occupying any land there, she is not liable to be evicted.
That's what I'm also praying, lordship.
And if that be so, we'll direct the deputy commissioner to give him 15 days time to clear of this. She will also appear. 5/5 will pass it for further hearing.
May it pleases your lord. I beg to mention item 20.
You seem to be not keeping well.
I reached last night very late from Itanagar.
Oh,
Is the reason I just need accommodation. May it be fixed on 7th lordship, if lordship pleases.
okay.
I have to
You are in, but
I have taken the consent. I know it's too, it's an old matter. This.
all matter one, but what relief can we give you? You have already retired.
Yes, lordship.
You were under 49C.
Yes, lord.
49C, you are not entitled to any money. It's this one. You got district officer. All right. After that, you retired. Today, even if I permit you, you can't take over the charge from a retrospective date.
At least financial benefit.
No, charge you will have to take over. The latest law of the Supreme Court is that after retirement, you are not in a position to take over charge. If you are not in a position to take over charge, you are not entitled. Anyway, on 7, Ms. D. Ghosh, Learning Council for the petitioner, submits that the matter be adjourned today on account of certain personal inconvenience. Registry to list this matter again on 7/8/2025 for further hearing.
Deeply obliged.
May please, lordship. For listing of a contempt case, lordship.
Contempt will be before the senior bench. Senior bench.
May please, lordship. Number 8.
Item number?
Affidavit and reply has been filed.
What is the stage of the inquiry? But I had asked for a query as to whether the 20 lakhs can be maintained there and the balance can be allowed. What happened to that? You have got any instruction? No, to that extent, they have not filed. Okay. Call your affidavit. But Mr. Counsel, you have not explained anywhere how this money came to your account. Admittedly, the money has come to your account. So if that be so, your account should be subject to scrutiny.
But that 20 lakhs may be kept.
No, it's maybe not be 20 lakhs. It may be more than that also. So, but once you have been a part of this money laundering thing, how can this court protect you?
No progress is there, man.
Okay, you get your thing. Hallelujah.
May it please your lordship.
Yes.
May it please your lordship, with regard to item number 9, we have filed our affidavit on 29. Kindly the record be called for lordship.
You have filed your affidavit
Yes, lordship.
on behalf of the petitioner.
Yes, lordship.
Affidavit in reply.
Yeah.
Okay, we'll have it for admission hearing then. I've not seen the affidavit in reply.
Matter may be called, record may be called for lordship.
Anil, let it come. Mr. Borua, this is beyond the time. Right? 36, 38 and 42, 42. You have not complied with. These are 2006-7 to 2007, 2005-6 to 2007-8. One notice, 3 assessments. These assessments are beyond the time limit preferred by the statute you only created. The petitioners are here. Okay, okay, there was an adjournment slip. Yes, sorry. Then I just read it. Okay. Mr. D. Borua. H. Borua, Lanark Council for the petitioner, for the Finance and Taxation Department submits that the matter be adjourned today and be taken up on. We'll have it on 12th, 12/8/2025. Raised prayer is not objected to by the Lanark Council for the petitioner. Registry to list this matter again on 12/8/2025. 12/8/2025 for further hearing. Why? What happened? Mr. H. Borua, Lanark Council for the petitioner, submits that he be granted for filing affidavit. We have filed submits that the matter be adjourned today on account of certain personal inconvenience of the arguing counsel, Mr. B. Chaudhary, for registry to list this matter again after 3 weeks on a date to be fixed by. This is 25. We can.
But then there is an interim order and I'm.
Interim order interim order passed earlier to continue until till the next date of listing.
I need to mention item number 14.
14.
Estimated a parallel proceeding cannot go simultaneously in state GST as well as.
But you have not filed your affidavit.
I have not filed my.
File your affidavit, we'll see. How will they know? They'll also have to object. You have been taking time after time for this.
Convey my department.
File to the action. No. So the 14.
14 years.
That we don't know. If you want, you can amalgamate all these proceedings. So 12/3, 10/4, then again 25/6. How long further you want? So some costs now. You impose interest on the assesses if they are delayed. So we'll also impose interest on you. If they're not interested, they'll pay the amount. There are 2 proceedings in against you. Mr. B. N. Gogoi, Learned Counsel for the Learned Standing Council, GST, prays that he be granted a week's time to file his affidavit in the matter. 2 weeks' time to file his affidavit in the matter. So it is seen that the Learned Council was repeatedly praying for adjournments in the matter on the earlier dates of listing for the purpose of filing his affidavit. However, the said affidavit is yet to be filed. So accordingly, as a last chance, an opportunity is granted to the respondents to file their affidavit on or before.
Permit me.
No, 2 weeks, not a day more than that. Otherwise, it will be starting with 50,000 now. 31/7/14 on or before 18/8/2025. So in the event the affidavit is not so filed on the next date of listing, this court would consider to dispose of the present petition basing on the materials already available on record. So registry to list this matter again on. We'll have it on 26/8/2025. Any interim order? interim order passed earlier to continue until further orders.
And deep level.
May
Mr.
please-
Gogoi, we have not imposed any cost today, but next time you don't do it, it will start with 50,000. We are not going to bear all those things.
Wait, please, your lordship. Wait, we have filed our affidavit, your lordship.
20,
Page 28 of the supplementary call.
they have filed an affidavit, government,
Also filed that.
but
affidavit.
both the affidavit and this thing is not on record. When did you file?
I received it on day before yesterday.
Get it on record. You also give a memo. Both the affidavit. In the writ petition, they have filed an affidavit. Get it on record. Please give a requisition for both.
Hello, item 17, item 7, I want to do with consent of.
That matter lordship already.
But we'll have to impose some cost then. Mr. Sharma is insisting.
For constable, she has.
But
she
this is a misrepresentation you have made before this.
That's true, Lord.
has no land, but his husband has some.
That is, that is enough. We are not considering her as an individual. It's a family. So how much cost?
No, madam. Consider first time. Madam.
This type of litigation is.
This type
Yes,
of
yes, madam.
litigation we will not
Yes,
permit.
No, madam, first time.
You have not even mentioned about the land of your husband and the family.
In
How
the-
can this be?
In the application.
Yes. If you want to withdraw, we will impose cost. Otherwise also I was to impose cost. You determine the amount, come back when the matter is called. We'll take it seriously. I may change my mind also. Let the matter come up, Mr. Amit. Not a lenient view. This is a misrepresentation before this court. You had forced this court to issue a notice in the matter, basing on your statement that you are a landless person. But it seems that your family has abundance of land. That means you are trying to overreach, misrepresent.
3,000, madam.
Hmm?
3,000,
10,000,
5,000, madam.
10,000. No bargaining here. Mr. J. Ahmed, learned counsel for the petition, a file to the auction, item number 7. On instruction submit that the petitioner desires not to press this matter further, and accordingly he prays that the matter be permitted to be withdrawn. Also, a perusal of the records would go to show that the petitioner in the writ petition had projected that she is a landless person and accordingly had approached the respondent authorities praying for allotting to her a plot of land in terms of the land policy in place. Also, the said prayer of the petitioner was countered by the state respondents by way of you had produced some instruction,
I'm placing it.
had produced, had. The petitioner in the present proceedings has prayed for a direction upon the respondent authorities to consider her case for allotment of a plot of land by projecting that she is a landless person. Where is that 2811, 22? Full stop. The petitioner had also challenged a notice dated 28/11/2022, by which she was required to vacate a plot of land illegally occupied, vacate the government land illegally occupied by her in front of Kolgosia Primary Health Center. Full stop. The projection in the writ petition being to the effect that the petitioner belongs to a landless, belongs to a family not having any land, this court had proceeded to issue notices in the matter. However, Mr. H. Sharma,
Lordship, I'm sorry, Lordship, in that I have marked it with red pen.
Let's know,
And
it's-
may I place it this one, Lordship? Yes.
it's okay. It's good for me. Mr. H. Sharma, learned counsel for the petition, for appearing, H. Sharma, learned government advocate appearing for the jurisdictional deputy commissioner, has on instruction submitted that the petitioner's husband, Akbar Ali Mullah, is running a shop on a government land and has and further that the family of the petitioner has 5 bigha, 2 kotha, 10 lesa of land recorded in their name under Colgasia Revenue Circle. In view of the above position, Mr. J. Ahmed, Learned Counsel for the petitioner, is not in a position to dispute the said submissions made by Mr. H. Sharma, Learned Government Advocate. In view of the said position emanating in the matter, Mr. J. Ahmed, Learned Counsel for the petitioner, prays that he be permitted to withdraw the present writ petition. Admittedly, in the present writ petition, the petitioner has not disclosed the fact that her family has land recorded in the has possession of 5 bigha, 2 kotha, 10 lesa of land under Colgasia Revenue Circle, and accordingly has misrepresented before this court in the matter by projecting that she is a person who has no land allotted to her in her name. In view of the above, while accepting the prayer of the Learned Counsel for the petitioner to withdraw the present writ petition, this court imposes the cost of ₹5,000 upon the petitioner for the misrepresentation so committed. The said amount would be deposited in the registry of this court within a week from today. The registry, on receipt of the said amount, shall forward the same to the Guwahati High Court Bar Association for its developmental activities, for use by it for its developmental activities. With the above observations and directions, the present petition stands dismissed on withdrawal.
15 days. I'll.
Okay, within 15 days, 2 weeks or 1 week, is enough. 15 days.
That may be kept as a part of it.
The communication dated 1/7/20, the instructions dated 1/7/2025, furnished by Mr. H. Sharma, is kept on record and marked as X for the purpose of identification.
Hello.
Mr. Ahmed, lady and you are there, so I was a bit lenient.
Item number 1 to 4.
Oh, mention Suli is dispose of. Dispose of. But you will get the order by Tuesday or Wednesday, not before that.
5.
Yes, where is Madam Devi? Yes, what have you found out? How much are you paying? Okay, then we will decide. You have no provision, we will decide. I told you, I am giving you the liberty to recover it from whomever you want to, but pay the amount to the petitioner. Poor man, he was working for your development. You have a vicarious liability then. They are working for your contractor. Okay. Miss R. Devi, and Bora, you also have no instruction. Yes.
Lordship, as per the work order was issued. Just like the petitioner, my lord, he was the labor.
Where is response number 5?
21, my lord, I have no communication.
Where is that work order? Is it on record?
They have not
You have to annex. You are the employee.
the work order because.
Where is the work order, Madam Devi? Where is the work order? Of your affidavit?
Not in any-
Where is that? Page? Hmm? Of your affidavit. Rita Devi, yes. No, I want the contract. I want the order. Okay, letter of acceptance. So who are behind this SEC, RSI, LP, KE, JV? Between? Who are the persons involved? Who is representing SEC? Who is representing RSIPL? Who is representing KE? Get that information. We'll zero it down. You want the money? Yes. Ms. R. Devi, Learning Council for the petition, for the respondent railway has submitted that the railway authorities have instructed her that they have got no liability in the matter, in as much as the husband of the petitioner, the husband of the petitioner number 1 was employed by the contractor, that is Messrs. SEC-RSIPL-KV-joint JV in terms of the letter of acceptance issued to it on 44/9/2018. Ms. Devi, on the next date of listing, shall place on record written instructions received from the respondents with regard to the officers of the components of the joint venture entity to which the addresses of the companies involved in the joint venture, along with the details, particulars of its officers on the next date of listing. Registry to list this matter again on 11/8/2025. We'll record it when it comes to. That's why I'll make the party. You give me the details, I'll make them the party. This is not an adversarial thing. Man working without security measures, I could not lay my hand on that. I'll get that also. You also try. Railways, the work when they give, there is a certain set of guidelines also issued that the person working has to have this much of safety factors. He was that gate was up and he was in the top. That's can't help it. You just make a research on that. I'll also do. I have that somewhere. I'll try to find it out. And if we have to go in, madam, you will be subject to appeals and all, but this court will be harsh. You have got the SLC minutes?
Okay, the second page will also.
This is the only round. Have you examined the fact whether she was during the school hours working in the school and thereafter she was doing classes here? Her claim is that during the period she was allotted classes, she was doing it. And then for a few classes, she is to go there. How can you restrain that petitioner from? Because she is continuously working here. And this is just a contractual, it's not a regular appointment. Then, just for the purpose of rejecting somebody's case, you have taken up a plea. DLC knew about it, the school authorities knew about it, they have not made any comment on this. Ms. Mushari, we are interfering with this. Right? Hmm. 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 Okay. I missed this. Okay, this information was given to some RTA. Hmm? Ms. D. Musahari has placed on record the minutes of the state level committee. Minutes of the meeting of the state level committee held on 4/12/2020, wherein the case of the petitioner for provincialization of her services on consideration came to be rejected, holding that she was found to be working as a contractual teacher in Kendriya Vidyalaya, Narangi, Guwahati up to February 2012. Ms. Musahari has further placed reliance on the attendance of the petitioner in the school as set out in a RTI reply issued by the principal of the school in question on 24/9/2020. Ms. Musahari shall give a copy of the same to the learned counsel for the petitioner, Mr. R. Goswami, during the course of the day. So, Mr. R. Goswami shall complete his instructions with regard to the same and place on record materials to demonstrate that the petitioner, while under working as a contractual teacher in the said Kendriya Vidyalaya, was also attending to her duties in the venture school concerned. So how long will it take? 2 weeks?
2 weeks.
Mr. Goswami shall place the instruction on the, shall place the clarifications on the next date of listing. Also, raised to list those matters after 2 weeks on a date to be fixed by it. Full stop. The matter be not treated as tied up with this court any further.
Obliged, my lord.
Just get that. It's boiled down to that. Now
Yes,
get
yes.
that instruction. Yes. Who is appearing for the respondents? Get Mr. H. Sharma. He'll be in a better mood. Yes, you are appearing for? Bank. Okay. You have nothing to do. Get Mr. H. Sharma. He will have instruction. Who was appearing earlier in this matter? Mr. Chetia, Mr. H. Sharma, Mr. S.S. Roy. Huh?
The time, my lord, senior colleague.
H. Sharma. Get Mr. H. Sharma. He may have instructions. Yes. Mr. Swege, you have filed a reply.
Lordship,
Unfortunately, I could not go through that. It has just come on
nothing
record.
except denying and the falsity in the report.
The pleadings are complete. Nobody is appearing for the respondents?
No, my lord, in spite of the receipt of the notice, my lord,
Okay.
now the,
It is. The pleadings are complete. We'll fix it for hearing. They are also not there. We'll give them an opportunity. Next date, we will dispose it of.
my lord, the hearing, can it be in the admission?
Admission only. I'm just fixing a date for just specifying that we'll dispose it of on that. The heard Mr. P.J. Soikia, Learned Counsel for the petitioner. Learned Senior Counsel appearing for the petitioner, assisted by Mr. R.K. Talukda, Learned Counsel for the petitioner. Heard Mr. P.J. Soikia, Learned Senior Counsel, assisted by Mr. R.K. Talukda, Learned Counsel appearing for the petitioner, and Mr. N. Das, Government Advocate. It is stated at the bar that the pleadings in the matter is complete and this matter can be taken up for final consideration by this court accordingly, as agreed to by the Learned Counsel for the parties. After 14th, any date,
22nd of August.
on 22/8/2025. Registered to list this matter again on 22/8/25 for admission hearing. An endeavor would be made to dispose of the matter on the next day.
Obliged.
Now, if they don't come, it's there.
Lordship.
Well,
Order to continue.
interim order passed earlier to continue until further orders.
Lordship, this matter pertains to issuance of transfer certificate.
No,
Uh,
Where are the seniors? Timing will not be possible today. This court in second half, there is enough work. Someday. Okay, we'll see. Yes, Mr. Bhuya, where is your affidavit?
As per the articles in that affidavit, claim amount of
Lakhs.
That is the tendered amount. His bid, 9358, 609. And you have paid 44. What about the balance? So you are admitting the dues. Where is your affidavit?
affidavit we have.
No, how can I? You just file it, we'll dispose of the matter. When, you give me a date when you are filing it. Okay, done. Mr. M. Bhuya, Lanark Council for appearing for the PWD department, respondent, submit that the affidavit on behalf of the respondents represented by him is prepared and would be filed on or before 7/8/2025. Also, registered to list this matter again on 11/8/2025. It's only if they admit it, we are disposing it of, directing them within a time frame to pay you the money.
12, my lord.
12, no, 13.
13.
13.
Lordship,
28.
The Lordship, Sir Ken Chaudhary sir is in, your Lordship.
I don't have any more matter left. Anyway, we are keeping it for the time being.
Obligation.
Arebar mati baje, nahi kum. Arebar mati.
17.
Yes, Mr. Chaudhary, what has happened? Have you complied? Where is that order?
soft copy lordship, can it be taken up?
Okay, done.
18.
But I am appearing on behalf of Mr. Francis Sharma. Madam. He is out of station, out of India, in fact, madam.
Last time also you made this prayer. That's why we placed this matter
Sir,
today.
Can it fix on after 11, any day order, sir, continue.
Another aspect is there.
Me,
Page 63, madam. Page 63, madam, the order is
Round of litigation, lordship was appearing.
64, madam. Okay.
This is the order.
That's it, okay. Order.
I checked up here. Oh, this I missed out.
Madam.
Raised it to list this matter before any other bench without me. Munnam to likhi dibo. I missed it.
Deep level.
Sometimes when you get involved in the issues, you've missed something. Okay.
Deep level.
The pleadings are on, your written arguments are on record.
Yes, yes, your
So what we do is we'll fix it for delivery of orders.
Lordship,
The Lanark,
if it's not inconvenient to this honorable court, can it be fixed at 2? Because
today, no.
on any other day than thereafter,
Why?
might be your lordship had some query.
We don't have any query. We are satisfied. We'll have to pass the order now. You have given your written argument. She has also given both very well drafted. The Lanark Council for the parties have brought on record their respective written arguments. Hearing concluded. Registry to list this matter, but it will take some time. Does this matter again on 26/8/2025 for delivery of orders.
Your lordship may keep one more date. Maybe my senior have to clarify on some issue.
No issue.
That's what he has
No, finished.
asked me to do, your lordship.
Done with. No further. He has
Hardly-
elaborately dealt with the matter. What more can he, what is left to say?
But basically, he said me, therefore I'm praying before your lordship. I hardly take 15-20 minutes.
Ka- ka- continue. Mr. R. Sinha, Learned Counsel for the petitioner submits that the the Learned Counsel for the parties have brought on record their respective written arguments. First of Mr. Sinha, Learned Counsel for the review petitioner submits that he be granted a week's time to make further arguments in the matter on certain aspects which have come to their notice after the last date of hearing.
Your Lordship, actually, they have handed over
I'm
me the
not-
written argument just now.
Forget it. How can that be? That cannot be a ground.
Oh, your Lordship will keep it for delivery.
No.
No,
No,
no, your Lordship will-
now I have passed it. Raised it to list this matter again on 26/8/2025 for further hearing.
Your Lordship will keep it for
No,
delivery.
no,
or-
two prayers, one accepted, done. Now you come.
Anyway, Deputy Organizer.
My senior is on legs in court number 4, Your Honor.
If it doesn't come in the second call, I'm dismissing it for default.
Okay.
None appears for the parties on call. The registry to list this matter again after 4 weeks, 3 weeks on a date to be fixed by. You was here, Ms. Das was here. Ms. Das, your case, yes. Before the list is over. None appears for the parties on call. Registry to list this matter again after 2 weeks, 3 weeks on a date to be fixed by. Where is Mr. Gogoi? Just find it now. Arabar Matidia. Yes, Mr. Sharma, any material?
Material from the affidavits is reflected.
No, but what we had proposed, asked you was a query was raised whether by keeping the 20 lakhs, you can release the bank.
Yes, Lordship. Initially, that was the view. I have also submitted
Hmm,
reports on our report, and accordingly, I had contacted with them and at the
Hmm,
top.
Hmm.
They have stated that no, there are several this type of things going on. And in our affidavit, the last affidavit,
Hmm.
is filed by
Mr. Kohli, you have a matter? Mr. Kohli, you have a matter?
25, I just reached, but we passed it over.
TOL 25 too? Oh. Continue. We'll just call it after this.
in page 57, the affidavit filed by Numal Mahatta.
Nomal Bhatta, huh?
This in page 57, paragraph number 4.
Hmm.
Recently, that the Department of Finance to submit that the case involved fraudulent transaction of rupees 7.40 crores by duping the victim's informant of this case by falling into the prey of the first.
No, you have not said anything with regard to the petitioner here.
Yes, Lordship may kindly come to page 58.
Huh?
Page 58, last paragraph.
Hmm.
The process of analysis of the bank transactions cannot be logically concluded until and unless all the account holders, proprietors of the involved bank accounts are properly examined and the chain of transactions, credit and debits are properly verified with the required documents. Due to the involvement of several bank accounts being operated by different account holders, proprietors who are residing in different locations outside the state of Assam, the process of analyzing the bank transaction could not be progressed as desired, hence could not be completed till date. Further, no logical conclusion can be made by any particular bank account till completion of analyzing the transactions of all the bank accounts involved.
You find out his role.
But the second one, the KYC which were provided to us, those are mismatched.
Mr. He is before us.
Lordship.
A person, others are not before us. He is before us. His grievance is that this is the thing. You examine him. You have not even examined him till now. You have him, interrogate him, whatever you want to do, come to a conclusion. And thereafter, tell us what to do. Mr. I'm fixing this matter on Tuesday. On that day, you receive your instruction. What is the time period you will require for having his thing considered, for integrating him and coming to a conclusion with regard to this account. Admittedly, the first account, if we call it, wherein the money was deposited, from there, money was transferred to various accounts, and one of the account is of the petitioner. Find his complicity therein.
That 20 lakhs has been deposited
Huh?
in the first affidavit. it is said
Initially,
that 20 lakhs.
I myself submitted before the.
I know that.
Honorable Court by
No,
keeping
no,
the
no,
20,
fine, fine.
but thereafter, Lordship.
No, we are also not passing any orders today, but you have your IO, have a conference with the IO and come to apprise this court. What time? You can't let this man hang like this.
My lord.
Find out how the money came to his account, because he is also not disclosing why this money came to his account. He has not even said that this was erroneously done by somebody. He has not. So this money he had received in pursuance to certain meeting of mine somewhere. Find that out. Come tell us.
That can be taken off. Whatever the money is deposited in my account.
No, no, Mr. Counsel, that's not a question. You have not said that this money was deposited without my consent. You have not said anyway.
Businessman, many transaction has been made, my lord.
Then we can't help it.
It is 20 lakhs.
If it is
More than that.
If it is find out, then that amount. will be
Okay,
all mine.
Mr. H.K. Sharma, Learned Counsel for the petitioner submits that he would receive instructions from the investigating officer as to the time frame required for completing the investigation in the matter with regard to the amounts deposited in the petitioner's account. Post op, he submits that the matter be taken up on 7/8/2025, on which date he shall apprise this court of the instructions so received by him in this connection. Registry to list this matter again on 7/8/2025.
70.
7. Just give me that time frame. That's all. 25 to multitude.
Hello, Lord.
I'm so grateful, Lord.
It's okay, Mr. We want to hear, but if nobody is there, then can't help it.
This one, Lordship, I had just a request. This is, I'll give an overview. We are waiting for the other side, just to let you know what the matter is.
Who is appearing for the other side?
Fido was there. She was there last time also.
Because this matter, they may not be aware, because this matter was under CAV. It was already heard and reserved.
It was
And then
reserved
unfortunately it was,
Judgment didn't come.
it was relisted.
So I will just, because we have to wait for the other side, but I'll give just an overview if Lordship would permit in 2 minutes. What is the issue?
Mr. Kohli, what we propose is,
Lordship,
let's
Mr.
not
Manager?
have the hearing one-sided.
Yes, Lordship.
Let the sides come. What we do is that they may not be even aware of this. They may
It is
have
possible. It is
left
possible.
also.
It is possible.
Mr. Abha Bachcha, she normally appears.
She does. That's right. I've not seen her from morning. I've been looking for her.
Aji hai na, not there. Okay, missed out also because they may not even have thought. Mr. Kohli, give me a date when you are comfortable.
Well, Lordship, if it can be maybe 20th of this month, next coming month, I mean, Lordship.
20. Okay, done. Heard Mr. N. Kohli, Learned Senior Counsel, assisted by
Miss Nimisha Menon and Mr. Anshul Malik, Miss Nimisha Menon and Mr. Kon Kalita. 3 of them are there.
N. Menon.
N. Menon. N. Menon, A. Malik and Kon Kalita. K.
लिख लिया ना?
Kalita.
लिख लिया? लिख ही लो word. Full stop. None has appeared for the respondents. Full stop. The matter has been listed before this court. after 26/3/2025. Accordingly, this court directs. The matter was admitted earlier.
In this, of course, even written submissions, everything.
Everything, I have gone through it.
I'm so great. Then Lord, the clerks will-
It's in that the matter was admitted for hearing on 2011-2017. Accordingly, the registry is directed to list those matters. Can it be on 21 if not otherwise inconvenient to you? It's a Thursday,
Yes, Lordship.
21/8/2025 for hearing. Also, in the event there is no representation on the part of the respondents, this court would proceed to consider the issues arising in the proceeding by after hearing the learned counsel for the petitioners. 21.
21, God. I'm so grateful. Deeply obliged, Lordship.
28. Mr. Chaudhary, the parties have exchanged affidavits, but this court is not having that on record. They have filed. What is the plea taken in the affidavit?
Plea is nothing, Lord. As per the statutory mandate, this contract cannot be given to
No, no,
private company.
the plea in the affidavit.
Plea in the affidavit is in terms of 7, 11 and 12, they are competent. Let us see whether they are
7,
11. If your lordship would kindly come to the.
lifting of
petition.
food grains.
In the writ petition itself, it is there.
7.
Please come to page 65.
I'm there.
Yes. Please come to clause 11 and 12 towards the bottom. State government shall devise suitable mechanism for transportation of food grains from the corporation godown to the intermediate godowns and doorstep delivery of food grains to the fair price shop, provided that the state government may also transport food grain directly to the fair price shops from the corporation godown and ensure its doorstep delivery at fair price shop. State government shall furnish a report quarterly on the basis to the central government. But my lord, can 11 and 12 be read dehors 7:1? State government shall leave food grains from the designated depot of the corporation to its authorized agency.
So,
Authorized agency is defined.
1,
Yes.
after lifting,
Ah,
11 and 12,
yes.
for my understanding,
Yes.
11 and 12, any device, any method they devise will be with the last two words in 7:1, authorized agency. Where is Mr. You are arguing? Where is he? Call him.
And my lord, authorized agency is defined at page 62.
62.
2G.
Department of the state government or a body corporate or a company owned by it
Or a
or a cooperative. So it
So
can
private
be,
contractor is nowhere envisaged.
it can be, if it was earlier,
Yes.
erstwhile state fed,
Ah,
it can be state fed, or
state-owned company,
it can be HUDCO, it
HUDCO.
can be anybody.
yes.
It can be given to anybody, but not to a private.
Private transport operator.
You are alleging that herein, by way of the MIT, they are bringing in not an authorized agency, but a
An
private
entity which is not envisaged
envisaged
in
in it.
definition of agency, authorized agency.
Mr. Chaudhary, one doubt.
Yes,
Say you are the authority to do it,
yes.
but you have certain limitations in doing it. Under your control, whether it would be permissible for you to devolve this to certain individuals, but they will be acting like under ASTC concept, whether that argument can be developed by the state.
Assuming, my lord, it
Hmm.
can be.
This is for my
In-
understanding.
In that case, can we be left in the list at the large, my lord? The cooperative societies were presently doing the work.
No, that would be the second part.
Yes.
But say the food and whatever public distribution department.
Submit is
Hmm.
clause 11 and 12.
I got it.
It does not. carve
Your-
out an
your
ex-
thing
does
is
not
very-
make a
very
member
simple.
An exception.
Okay.
Rather, 11 and 12 has to be read harmoniously with one.
Where is the tender? Tender is at page
Yes,
44.
Yes. E-tender under two cover system comprising of technical and financial bid are invited from Indian citizen interested in handling transport, having geographical knowledge of Tinsukia for selection and appointment as a handling contractor for transportation of food grains under so and so, so and so, so and so, and street air so and so for transportation and delivery up to fair price shops level so and so, so and so.
Mr.
there's no-
Chaudhary, just interaction. If you can come in two-tier system,
Yes.
tier one, from FCI go down to GPSS, WCC go down,
Yes,
and tier two from so-and-so to so-and-so.
yes,
So the contractor herein
Hmm.
will have to lift the food grain from the designated depot of the godown.
Hmm.
So it has to be in terms of 7(1), only an authorized agency,
yes,
at least for that part,
yes.
for that lifting part.
Mhm.
So from the FCI godown
Ah.
to the GPSS,
Ah.
it cannot be anybody other than an authorized agency.
Yes,
From GPSS to the fair price stop, there is no provision in the order,
yes,
but it's only lifting. If you can come to 65,
yes.
shall lift
No,
food
no,
grains.
it says a designated depot of the corporation. It doesn't say to where.
No, what I'm trying to project is
Yes,
to be authorized to get the food grains from
Ah.
the FCI,
Ah.
you must be an authorized agency.
yes.
So if we go by the tender,
Hmm.
lifting is not the only thing. Lifting and transportation to the GPSs.
Hmm.
That is one part,
Hmm.
which can be done according to you by a authorized agency only. With regard to the second part,
Hmm.
from GPSs to the
Whether,
that will also come here.
yes. No, my lord, I was only trying to understand one thing. If you please come to clause 11,
Yes.
it emphasizes that tier 1. State government shall devise.
Oh, it envisages both.
And doorstep delivery of food grains.
So it's a one transaction, it will be covered by one. That is your argument. And this court has already, division bench has already held
Yes,
that.
permitted.
My Lord Justice Soikia's order is, yes, that I just looking it at yesterday.
I think, no, division bench order was of, I think, Chief Justice Ajit Singh and Millard. Division bench orders.
Manojit,
Yeah.
no,
Page 144, Millard.
no, that is,
That's the order in the writ appeal.
okay.
Monojit Bhuma,
Manojit. What happened to this writ appeal?
pending. My lord, our only concern is now the private contractors are operating, Millard. The affidavit they say, and their affidavit, their only
And
stand
the
is.
stand of the government is that they want to empower the cooperative societies.
Yes. In fact, my lord, in this country now, all these institutions will die, my lord.
No,
Because-
the central government is now reactivating the cooperative sector.
No, but at the ground level, for example, my lord, the implementing agency is the state. Now see the state's action. Is in conflict with the central's about policies. In fact, even in case of procurement of uniform for all the schools and all, and also we have seen so many litigations. Central government policy is clear.
The learned single judge had
In the
Uh,
earlier occasion.
earlier occasion held in favor of the state,
State,
and that was then carried upon appeal.
yes. And appeal, my lord, virtually, my lord.
It has given the earlier practice to
Yes,
continue.
Yes,
You are not a part of this appeal.
no.
So even after the interim elections passed by this court, your cases in the IA
Yes,
that they are still continuing to do it indirectly The same method,
Directly through the private contractor.
private contractors. So it's basically an ad hoc measure now they have put it in place of the permanent measure. Do you have a copy of the affidavit? Extra copy?
Yeah, yeah.
sir.
They have filed it in the IA or in the main writ? I see. Oh, it has come, it has come. It's come.
Please come to page 45 of that IA, Millard.
Hmm.
It is stated that the present applicants and others had also filed another writ petition being WPC, wherein they have challenged clause 7, 11 and 12 of the targeted public distribution order, whereby provision has been made for distribution of PDS article from FCI godown to the godown of the intermediaries and doorstep delivery of food grains to the fair price shop by transport carriers contract. This is not correct. The aforesaid WPC was dismissed by the Honorable High Court by judgment and order dated so and so with the following observation. In respect of the petitioner challenge to the impugned e-tender notice for selection appointment of transporters, carriers contractor for lifting of food grains under the National Food Security Act, as this court by judgment and order passed in WPC had allowed the state respondents to finalize the tenders for selection appointment of transport contractor under National Food Security Act in relation to control orders. The other prayer of the writ petitioner for setting aside impugned tender notice is also not sustainable. The same is also rejected further. Then my Lord may kindly come to.
What is
One
this
second.
case?
No, one thing, I'm sorry. Okay, paragraph will look at that. Yes,
Okay.
please come to me, Lord, page 42, this
Okay.
subpara.
So you were also a part of
Yes.
the learned single judge's order.
Yes.
42, yes.
Subsequently, subpara in WPC filed by applicant along with others, inter alia challenge clause so and so under which the state invoked to initiate a tender process for transportation of food articles from FCI godown to fair price shops to private transporter. Honorable Court, while order dated, dismissed the writ petition by holding there was no merit in the challenge. In the meantime, judgment and order dated, after the judgment and order dated so and so, the Joint Secretary to the Government of Assam Food, Civil Supplies and Consumer Affairs issued a letter dated addressing the Deputy Commissioner of various districts of the state, including Deputy Commissioner of Tinsukia, to take necessary action, and consequently e-tender process was initiated by publishing a tender on so and so. Pursuant to the aforesaid tender notice, the Tender Evaluation Committee held its meeting on so and so. However, matter regarding financial bid was kept in abeyance till this. Being agreed by the aforesaid decision of the Tender Evaluation Committee, it is so and so, whereby opening of financial bid was kept in abeyance. One prospective bidder, namely Amar Dukan Consumer Welfare Society Limited, filed writ petition praying for direction to open financial bid. Anyway, their case is that in earlier round of litigations we were permitted, and moreover 7, 11 and 12.
This tender is of 25.
Yes. Question.
Their basic case is that
In the earlier round of litigation.
earlier litigation, this court had held that it is permissible. You have not gone up on appeal, 1. 2, the earlier litigation process, although there were some interim orders staying the effect of the opening of the financial bid, one of the bidders came up, that was also permitted to be opened, and then it was win. But they have not dealt with the
merit will not directly, but indirectly they are relying on 7, 11 and 7, 12.
But as you have said, subject tentative view,
Yes.
711 and 711 and 712 is immaterial. 711 cannot be read in isolation.
Yes. It has
It has to be read in 7-1.
Yes.
Or there has to be some material.
7-1 makes no sense.
Then why is the authorized? They could have just removed that 2 words. That would
yes.
have done the matter.
Yes. And the same is the spirit in the act also, my lord, section 24. No, Janu. ফটো ক'ত আছিলে? Section 24 টো ক'ত আছিলে? কিতাপখন আছিলে নে নাই?
Mr. Chaudhary, one
Yes.
thing,
Section
the
24.
earlier round of tenders were in 2017-18. And you made a statement that you were operating this thing before this NIT came into being. But your writ petitions were dismissed. What happened thereafter?
Thereafter, my lord, they engaged a private contractor.
After the
Even
dismissal,
now in the affidavit also they have
after
said.
the dismissal of your
Yes.
writ petition,
So kindly have this National Food Security Act 2013.
NFSA.
আছে নেকি কিতাপখন?
Should be there. নতুন set নেকি এইখিনি? এদিন মিলাই ল'ব। National Food Security Act.
পাতলা কিতাপ এখন। এখন দিয়কচোন। Lord, may kindly have a look at 24(2). Under the targeted public distribution system, it shall be the duty of the state government to
Mr. Chaudhary, just a second. God, my bad.
24(2). Under target public distribution system, it shall be the duty of the state government to take delivery of food grain from designated depot of the central government in the state at price specified in Schedule 1, organize intra-state allocation for delivery of allocated food grain through their authorized agencies at doorstep of each fair price shop.
An authorized agency is defined in the target.
Yes.
list. Any definition of authorized
I
agency
think,
here?
yeah, one second. Somewhere it says, any definition.
Essential Commodities Act to some. Essential commodities.
What does it?
Maybe in absence of a definition here,
Yes,
they
yes.
have defined it in the,
Yes, please come to 25, Miller. 225. Words and expressions not defined here, but defined in Essential Commodities Act or any other relevant act shall have the meaning respectively assigned to them in those acts. 225.
no, that I have seen.
So related statute is the Millard that order.
So therein that specific definition is
Yes.
there. So any lacuna here has been taken care in the,
My lord, this is absolutely crystal clear, Millard. Or lordship can refer this matter to the DB also if your lordship feels otherwise.
that may be too much. Mr. Chaudhary, just to boil down the things,
Yes,
you have an interim direction.
yes.
Now your further case is, in spite of that interim direction, staying the operation, they have not taken recourse to the measure for
And
transportation
division
as
bench would-
envisaged in the
division bench
targeted.
would like to ordain.
I'll not go into that. They have not taken steps in terms of the targeted public order. So it's bad. I will not say that they should be given, it should be given to you, I will go to the extent subject to what Mr. Nath says,
Yes.
that in view of the NIT being state, the state government is at liberty or the authorities are at liberty to have the distribution system
In terms of the
in
first
terms of your provisions of 22
2,
and
That order.
24 and that order by way of an authorized
in
agency.
the interregnum.
That's the only I can do. I'll just hear you. You can have your matters done.
Yeah,
I'll
but-
hear Mr. Not if something comes up, Mr. Devri
Let me
will
know.
ask inform me.
I'm deeply.
I think that much only we
Yes,
can do.
yes. Deeply.
It would not have one. It will get it later. Yes. No. Even 28, 17. Madam.
17?
Mr. Chaudhary, I've got the. What is the date? 28/3. None has appeared for the petition on call. Also, this court-wide order dated 15/6/2022 had disposed of the writ petition being disposed of WPC number 3910/2022 with the following direction, page 9 A to A. Also, it is seen that in pursuance to the said direction, the petitioner on 5/7/2022 had approached the chairman, Silchar Development Authority, and submitted a certified copy of the order, said order dated 15/6/2022. Also, Mr. S.P. Chaudhary, learned counsel for the petitioner, has today placed on record order dated, speaking order dated 28/3/2023, passed by the chairman, Silchar Development Authority, whereby the representation submitted by the petitioner was disposed of. Full stop. On a perusal of the order dated 28/3/2023, this court is of the considered view that the directions passed by this court wide the order dated 15/6/2022 has been substantially complied with. Accordingly, substantially complied with. Accordingly, there being no deliberate or willful violation of the directions passed by this court, the present contempt petition stands closed in view of the passing of the speaking order dated 28/3/2023. Full stop. Notices issued stand recalled. A copy of the order dated 28/3/2022, 28/3/2023, furnished by Mr. S.P. Chaudhary, learned counsel for the respondents, is kept on record and marked as X.
Timing 11 and 12.
Registry to list this matter as agreed to by the learned counsel for the parties, registry to list this matter again on 12th. Before that we can, after the Arunachal things and all, 12th. This week we'll be tied up. Interim order passed earlier to continue till the next date of listing.
He recorded parties because I had been instructed.
Huh?
I had been instructed to present the case to parties.
As agreed to by the learned counsel for the parties, we have said.
20.
Yes, Mr. Regas.
My case is very clear. Yeah, my lord, the daughter and mother approached.
Just show me
Yes.
any material available on record which will demonstrate that you are the mother and daughter of Kajal Dey.
Under similar circumstances, my lord, regarding entitlement of the illegitimate
You
children.
go before the trial court, get a declaration.
My lord, already this court answered on this point, my lord. Instead of going to the civil court, my lord, and my lord, relying on apex court, my lord, I'll have to place this.
Please do so. If there is a law, why should I not follow it?
My lord, first I will take your lordship that Nikita Sutar minor, that is Guwahati High Court ruling, my lord, paragraph 4 to 4, 5, 6 and 11. Sorry.
Mr. Counsel,
Lord.
not gone into deep. The very first paragraph, second paragraph shows that the mother of the petitioner was identified as a heir of the deceased employee.
This is concerned discussing paragraph 6.
Rameshwar, that will not come here. The question here is there is no material to show that you are the father except your
Yes,
statement.
my lord, my so far as my petitioner on
No, the IAF authorities have said that we have got no record of anybody being a wife, even of respond number 7, who was there before the substitution. She went to the trial court, got a declaration.
Yes, my lord.
Then they say it's only because of that declaration we have given. You don't have anything.
Lord.
After your marriage,
Yes,
during your marriage, the employee,
my lord.
in addition to being an Air Force personnel in IAF, Indian Air Force, was also
Missing
an
role.
employee of Punjab National Bank.
Subsequently, my lord.
Bidder as it.
Yes.
You were there? You were there at that point of time? The wife was there? There is no declaration that you are his wife. You're total stranger to the whole things as far as this
I
court is.
admit, my lord. My lord, that's in the year of 1995, my lord, I got the petition number 2 got married with that is my.
That is what I'm
Yes.
saying, Mr. Dekha.
My
Spending
only-
by spending your time here, you're not going anywhere. You go before the court, learn a trial court, get a declaration that you are the wife, then the daughter. They are bound to pay you. I can't make that declaration on the basis of the materials brought on record.
My madam birth certificate to till my graduation certificate, all the testimonials, my father's name is reflected, my lord, in all the even other voter.
Okay, you make your
this-
submissions.
And
So
all
you
the-
are relying on these two decisions.
My lord, if the authority concerned, my lord, if they examine my case instead of approaching before the civil court, my lord, already, my lord, it is, I filed a case of 2017, now 2025, I again approach before the civil
You
court.
show me something which will make me
It
satisfied
is true, my
that
lord. It is true
Kajal
that-
De is the husband of petitioner number 1 and the wife of petitioner number 2 or vice versa. whatever.
Only, my lord, our certificate in medical
That
certificate,
by itself will
that is
not
only,
do.
my lord. There is no
That by
dispute,
itself will not do.
no department from any side has disputed that this is, my lord.
Yes, they have disputed. They have disputed. They say that we have got no records. We have got no records.
Since my father-
Categorical statement.
Since my
You
father,
come
my
to
lord, given entry into. our
that is
service
what
book,
that
my
is what is was being doubt. Page 56, para 9,
lord. Very true.
right? Then the
Wrong down my father, my lord, why should I suffer, my lord?
that
And now,
that
my
that
lord,
is that
after
that
getting-
that we cannot
After
answer
getting this says.
because Mr.
I
This
understand,
will require evidences.
At this time, my, regarding my entitlement of father is disputed in question, my lord. At this stage, I have to prove that, yes, he is my
You prove.
father.
You go and prove.
Now, question of identity is, has
E.T. Datta was recorded as his wife in the above mentioned so and so.
is the first to.
However, a lady named Sheila De had approached so and so, 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 so and so. Recorded so and so. So and so held a presumption is that so and so. So and so,
My lord,
so and so.
regarding the lord, there need affidavit, no heard that they have said that we are not entitled.
No, if
Lord,
you
they
if
directed
the
authority-
petition number 2 is to be the child, at least some material is to be there to show that Binapani De had married or was married with Kajal De. Nothing is here.
Sending the matter before the civil court.
I'm not sending you. You have to go.
The dishonorable court may refer this matter before the authority concerned. They will examine our case. So, but if it's.
They are-
we
they are-
will
they
try
are-
our
they-
best to satisfy them, my lord.
Mr. Counsel, they are not in a position to do that because the employee had never made any declaration. Plus, the materials that you have produced will not do. There will have to be a declaratory degree.
At present, we are residing at our father's house, my lord. Still,
That's what, those are materials which you will have to demonstrate.
who will prove now? What evidence will brought, my lord?
And this matter is lying here from 2017,
Yes,
going
my lord.
nowhere.
And-
By this time, you could have had the declaratory degree and the pension.
2025, we approached before the civil court, who will approve that regarding accept these documents, my lord. These documents are very much also available for this court, my lord. If the authority concerned decide on the yes, or considering all the certificates, if they
See, here the case is that your father was traveling 2001, he was missing.
yes, my lord.
And that somebody had gone to the trial court, has
After
then
7 years.
by
yes.
forging documents got a
Whatever.
declaratory degree.
Yes.
You have not assailed that degree at any point of time.
And we have lodged an FIR, my lord.
What will be FIR
And then
do? This
criminal
is
case they have challenged before, it's still pending before this court.
fine, but what, that lady is gone, so criminal case is
My
gone.
uncle is still there, my lord. He's one of the accused.
Okay, but here, that decree that was given by the,
My lord.
you had never questioned.
I understand, my lord. Since about legal, my lord, they have not aware this fact regarding challenge.
And there is you knew about this decree because you have brought on record the copy thereof. You or, yes, you.
Before lodging of the FIR, it has come to our knowledge from our uncle, my
Then
lord.
why
From
did
our
you
uncle we
not,
came to know.
if you were so bona fide, why did you not proceed to get this decree annulled? You have not taken any step. You have accepted this.
Third chance may be given to department, let decide on our fate.
Okay.
my lord.
Whatever happens in the criminal case, that will hold the field. We'll dispose of this petition. You have a criminal case pending. Whatever happens in
That
that
one-
criminal
that
case
is-
at, say, after 10 years, 15 years, whatever
No,
happens will
no,
happen.
no, some immediate relief is
And-
taking, my lord.
For that, we can only offer you that you go before the civil court, get that decree annulled, and then tomorrow there might be another person coming up saying that I am the wife of Kajal Dey.
And my humble prayer, my lordship, since well, these facts, my lord, till date, my lord, even I came to know that my mother, my lord, when a housemate sees, my lord, crying.
I
So
have my sympathies for you, but I can't have misplaced
some
sympathies.
lordship, some with observation, lordship, may give direction so that we could approach before civil court. my lord. That
I'm
was
no
eventually-
direction. I only say that this is not maintainable, leaving you to take whatever.
In 2017 matter, at the 2020.
Mr. Doctor, not as the respondent counsel, as a senior counsel, what is the powers of this court in such situation? Because the only material I have is the petitioner number 2's educational certificates. Therein her name is preferred as Kajal Dey. But the employer, he has recorded as Kajal Chandra Dey also. So I can't come to a conclusion that the petitioner number 1 is the wife and petitioner number 2 is the daughter. So I'll have to dismiss this. That you're for the bank, and the bank is very categorical. Although the IAF is not that categorical, bank is very categorical that we don't know them. And you can be known only through the employee. And in the earlier cases, there was a issue as to whether in the Rameshwari Devi's case, the issue was that she was the second wife was a known fact. But whether she had formally married Rameshwar, that the other lady,
yes.
was the issue. Then the Supreme Court said, okay, forget her. Now that the wife status is there, the child will get the benefit. That is how the Supreme Court went there, subject to correction.
Very correct.
But here, I can't draw a line from for the petition number 2 through petition number 1 to Kajal Dey, late Kajal Dey.
My last submission, my lord,
Hmm.
after more than 8 years, if this honorable court, in fact, this case is.
Okay,
some
Mr.
Some observation, my lord, that we could approach the civil court, my lord. That's
I'll,
what-
I'll only say that it's, the
Yes, please.
liberty is granted to you to take recourse to such
Yes, my lord.
procedure as may be available
Yes.
under law
Yes, my lord.
for declaring, for establishing the fact that you are the wife
Yes.
and the daughter of Kajal Chandra.
Yes, my lord.
And if that is so done, the respondent authorities will act in the matter accordingly.
Absolutely, my lord. I'm agree.
Dispose of.
Yes, yes.
Same entire retirement when
No, that would be, because that is again a order of the trial court. She can't have that benefit for that period. Because she has not got that. That was what I'm asking him. He filed a civil criminal case, maybe a wrong advice.
No, she died
But-
already.
Huh?
She died, my lord, on 2020.
No. The decree stands.
Yes,
The decree stands.
Yes.
And the decree, if there are minors, they'll be entitled. But fortunately for you, there are no minors. Both of them have become major.
nature.
So a lifetime areas would only be available.
Yes.
But the issue is that decree stands. Payments have been made under that decree.
Yes.
For that period, you cannot claim again. I'll deal with it. Mr. Doctor, I'll deal with it.
Yes, my lord.
Friday.
Please be obliged.
Registry to list, hearing concluded. Naam gita sob likhi lo bode. Registry to list this matter again on Friday for delivery of orders.
26.
Then award.
Malakaro tammo table that judgment of right was it. Yes, Mr. Gupta.
This is an award caused by the industrial tribunal.
Huh.
Respondent council is.
They are not there for a long time. We are not even concerned. You make your submissions.
The basically case is that whether these concerned workmen were the contract workers or the employees of the AIW. Now, will lordship come to the
Mr. Dasgupta, your submission is the issue is whether, forget the reference. To understand the reference, the issue would be whether
the concerned workmen, affected persons, that I should say.
the concern,
Workmen,
they were represented by a union.
yes, they are represented by a union. Actually, their case before
Concerned workmen were employed
of IWAI,
by
Inland
Indian
Water Authority
Inland Water Authority of India or
or the contract labor
by contractors
employee.
employed by IWAI. That's the case.
The finding of the tribunal is that they are the employees of the contractor.
Hmm.
And they have done it. Now, the terms of reference is that, so your lordship will find at page 10, whether the action of the management of Inland Waterways Authorities of India, Regional Directorate Pandu Port Complex, Guwahati, Assam is justified in making casual system of working by engaging the marine vessel crew only for 89 days in one spell with 1 day break in perennial nature of work of IWAI, if not what relief the workmen are entitled to. Next, whether the management of IWAI is justified in not formulating the terms and of conditions of service of these vessel crew working since long years in perennial nature of work. If not, what relief these workmen are entitled to by IWAI. Whether the management of IWAI is justified in not paying the marine vessel crew consolidated pay as per the sixth pay commission as recommended by the meeting in a meeting of the chairperson with the field directors of IWAI on 4/5/2011.
Hmm.
If not, what relief these workmen are entitled to. Basically, these persons were working as a crew personals of Inland Water Transport Department. Their case before the court was that they were engaged for a period of 89 days on a contract basis. And this thing is
How
being-
many workmen were there in total covered by this?
now in present case there are 25 workers.
No, means in that reference, how list that was appended, how many were there?
25 probably.
24.
Now they were engaged on the contract basis for 89 days as a
Mm.
crew personnel. Now now the
But there
India-
is no appointment order.
There is no appointment. That is the hurdle which is being, my lord. There is no appointment order, but they subsequently decided that these crew personnel which were engaged by them on contract basis, they will be engaged by a contractor as a contract laborer. Not, they will not engage the IWAI on directly on contract basis, rather they will be shown as a
Correct.
outside. That is the case. And as they have no order of appointment, they could not establish their case probably. That is the case. And it is also an admitted fact. If we go through their representatives, go through their WS, now you'll come page 11. Let us read. The case of the respondent, respective representative of IWA, Marine Workers Union, is that till the joining, the workers whose name has been mentioned is Annexer A, were employed with the management of IWA till 2007 as contingency staff of the vessel of IWAI at a lump sum monthly wages, though there was no appointment letters. During that period till 2007, the monthly wages were paid to the workmen directly by IWAI. But thereafter, such payment of the workmen was made through IWN, Assam Sector Marine Workers Development Society. This is the contractor blood. It is further stated that the worker without prior discussion with the aforesaid society or any of its members of the management of IWAI entered into an agreement with the private parties, namely Messrs. A.C. Rai and Company, Kolkata, and Messrs. China Shipping and Infrastructure Limited, Private Limited, Mumbai, to man, operate, and the main 5 survey launch vessels of IWAI. It is further stated that 25 numbers of workmen in the aforesaid vessels continued survey under direct control and supervision of IWAI, and only the monthly wages were paid to the workmen through the above contractor. Through the above contractor. It is also stated by the application dated 11/4/2023 and 24/5/2003.
94 members.
The workmen members of the society raised industrial dispute for protection of 94 numbers of marine vessel crews in the view decisions of IWA engagement of the contractor to man, operate, and maintain the vessel owned by the IWAI. While raising the industrial dispute, the workmen demanded the issue of identity card, pay slip, implementation of 6 pay commission, DA as per new rates, overtime as per the new rates, yearly bonus, EPF, ESI, leave duty, uniforms, safety shoes, and other existing facilities provided by the Government of India to the contingency vessel crews. The Office of the Regional Labour Commissioner, Guwahati, issued conciliation notice dated 30/4/2013, fixing the date 8/5/2013 as the first conciliation proceeding. Thereafter, the conciliation continued and held a various dates, but no settlement could be arrived at. Because of the non-responsive attitude of the management of IWAI, accordingly, the failure report of conciliation dated 9/10/2015 was sent to the appropriate government by Assistant Labour Commissioner Guwahati. It is also stated in the claim application that IWAI, being the state within the meaning of Article 21 of the Constitution of India, ought to have been model employer, but to the contrary, they resorted to unfair labor practice. In Annexer A of the claim application, a list of 87 workers are submitted who were stated to have been affected adversely due to the anti-labor attitude of the management of IWAI.
So
On-
this is your stand
Hmm.
before the tribunal pleadings. What
Tribunal-
was proved? What is the evidence adduced?
Evidence, there is oral evidence only, beloved.
Para 6. Whether these aspects were established by way of that evidence?
Yes, what that is to be similar. One witness was examined by the workman side, whereas the management side did not examine any witness. The workers witness, the workman witness Sri Jiten Deka stated that he has been working as a workman under IWA since 16/11/2003 and also did hold the post of working president of IWAI, Marine Workers Union. He stated that the members of IWAI, Assam Sector Marine Worker Development formed in 2004-5, has raised objection against the outsourcing of work to agencies by common company in regard to managing operation and maintenance of works vessels owned by IWAI. The witness also stated that during the conciliation proceeding, though the IWAI had engaged contractors against 5 vessels on paper, practically the workmen numbering 25 were under the direction and control of the supervision of IWAI. That is their specific case. Though we are shown to as a contract laborer, in fact, we are working under the direct control and supervision of the IWAI. The witness exhibited certain admitted documents, namely letter dated 25/4/2003, raising industrial dispute, Exhibit A, another letter by the union to the Assistant Labour Commissioner, Exhibit B, another letter written by the Assistant Labour Commissioner, Guwahati, Exhibit C, Management IWC Exhibit, to the Management IWC Exhibit, minutes of the conciliation proceeding, Exhibit D, letter written by IWA to the Workers Union, Exhibit D, letter written to the Assistant Labour Commissioner, Guwahati, Exhibit 5, the failure report, sailing order for the vessel dated 29/1/2026, Exhibit 8, letter written to the management of IWT as Pandu, Guwahati on 29th by 25 workers. It may be mentioned here that Exhibit 1, they have stated that they do not want the work under any contractor because they are facing many problems regarding salaries which were not regularly paid in time. They also stated for the above position, they do not have any future safety and hence they requested the management to absorb them in their establishment directly.
What is this context of this statement, last line that you have now read? That letter Exhibit 1 saying that they should be allowed
That was a request made by the workers to
So that shows that they are under a contractor.
They were shown as a contractor, yes.
This also
Yes,
shows
right,
that
yes.
they are under a contractor.
They are under a contractor.
But here the witness, okay, during cross-examination, the workman,
Witness Jiten Deka admitted that he has no document to show that he has been working directly under IWAI since 16/11/2003. He also stated that 3 workmen in the list of Annexer A are working at Kolkata. He also stated that he did not submit any document to show that the workmen involved in the present case are employees of IWAI. He also admitted during the cross-examination that the sailing orders for vessel Exhibit 8 was in respect of the persons employed under the contractor, namely Messrs. A.C. Rai and Company.
so this, Mr. Dasgupta, subject to what you say, this totally destroys the case of the petitioners. What is the conclusion?
Conclusion,
para 14.
para first issue of the reference whether the management is justified in employing the workman on casual basis to perform the works of the perennial nature. That is very much important. Two aspects are involved in this case. Firstly, whether the concerned workmen are under direct employment of the management on casual basis. Secondly, whether the nature of the work they perform is of perennial nature. Meanwhile, it may be mentioned that no notification, that is wrong conception. Lord. Meanwhile, it may be mentioned no notification
This
under
is not-
Contract Labor Regulation and Evolution Act prohibiting the engagement of the contract labor was issued by the.
This may not be correct.
Hmm?
This line may not be correct.
This line might not be correct. But
Since
that-
it has been.
But that merely because of this observation, the decision should not be altered.
Cannot be altered.
Cannot be altered.
Since it has claimed on behalf of that they are being performing.
Prohibiting the engagement contract was issued by the concerned government in respect of present employer, since it has been claimed on behalf of the workmen that they have been performing duties of the perennial nature. The burden of proving the same is upon union. That is a admitted position to maintaining a national waterways. Definitely
No.
it is a river Brahmaputra.
No,
Definitely
she
it
said
is a-
that
it
claim
is a
that they are in the
nature.
perennial nature,
Brahmaputra-
fine.
but
The argument
Brahmaputra
of
is
the,
flowing to us for more than 1,000 years.
no, Mr. Dasgupta, the next line is important.
But merely because they are this work is of the perennial nature does not confer the engaged person as a direct employee.
Okay.
That is I
No, the
noted.
next line would
The
be.
claim of the workman has to be accepted to be proved. The claim
No,
of
no, no, they just before that, they are the argument of the workman's side.
the argument of the worker, since the management side did not adduce any evidence, the claim of the workman has to be accepted to be proved. Probably this is not correct. Well, only because they have not.
That is the beauty of Mr. Dasgupta, a senior counsel being very fair. That's the correct thing. That's what I like to hear.
When a judgment is made, rendered, it is incumbent on the judge to what is the case of the petitioner, what is the case of the respondent. What is
Then
the
come to a
issue for-
conclusion.
That's true.
But there is absolutely no evidence to show that the workmen have been under the direct employment of the management on casual basis. So and so. In the entire evidence of the workmen, including the evidence adduced in the miscellaneous application, nothing to support. On the contrary, there is straightforward material to show that the workmen have been engaged in the concern through practice.
Hmm.
So
In the,
your case was
as was
finished.
found from this.
Para 7. The evidence cross-examination of J. Decca.
That is one aspect. And another case is that we have, though we were engaged as a contract labor, but the contractor has nothing to do. We are
That-
directly working under the supervision of the,
But the
that
unfortunate,
aspect of this case remain unassailed.
no. Mr. Dasgupta, subject to what you say, that aspect of the matter was not demonstrated or exhibited or proved by the workman before the tribunal.
Yes, yes.
Because by this para 7, I'll go through the statement. But by para 7, it reveals that he had not brought on
That
record.
he has no document to show
So-
that he has been workman directly. Yes, that is, there is no document. But what,
No, the last line. He also admitted during cross-examination that sailing orders of exhibited so-and-so was in respect of persons employed under the contractor, namely so-and-so, so-and-so.
no, he also admitted during the course of the sailing order of the vessel exhibit such and such was in respect the person employed under the contractor, namely SAS. Yes, that is, they were shown as a contract labor. Initially, they were engaged as a contract.
His statement is available here, cross-examination.
Subsequently, they were shown as a contract laborer.
There are also no documents except B enclosed with my evidence to support the case of the. I have not exhibited any document to show that the workmen involved in the present case are employees of IWA. He is himself finishing off the matter.
No, that is true. What he cannot develop his case on otherwise, because fact remains same that they were engaged by the IWAI on contract basis for a period of 89 days. And subsequently it is extended from time to time.
But
All
that
on a
aspect-
sudden, AIW took a decision that instead of engaging this contract basis, let them engage through a contractor. And they subsequently they become the employees of the contractor. Now their case before the management authority that though you have engaged the contractor, but it is nothing but a paper arrangement. We are working under the direct supervision of the IWS.
But unfortunately, your witness could not establish these matters before the tribunal.
Only by oral statement he had said so.
He should have exhibited documents. He should have brought in more evidences or oral evidence even he should have asked the management or the company which had engaged him to come cross-examine. Then maybe something would have come out. But with this material, we have 226 power. Certiorari. Thank you. But Mr. A. Dasgupta, Learned Senior Counsel, assisted by Ms. B. Das, Learned Counsel for the petitioner. None has appeared for the respondents. Hearing concluded. Registry to list this matter again on 11 or 11 or 2 Natayim. 14/8/2025 for delivery of orders.
29.
The judgment, Lordship.
Oh, where is it? Arunai. I give you Arunai. Okay. We'll come back at 2. Now there is nobody. 2 and we'll hear. And ask Mr. Nutt to be here at by 2. There are 28. Item number 28 to us. Eto respondent kuni bolaibo. Aru e Indrajit Talukdar to. Night to night kuno. Duta bajat aibo dibo. I got dispose kori bolaibo. 28 to. 28 na I to. I to kuni bolaibo. Senior counsel koi gol itia to not has. My judgment to mutarism silent.
Lordship, another similar judgment I have found.
The problem here is not on the law or the facts. It's the problem is conceptual. So I'll have to get myself cleared from that.
Time to go through.
Welcome back.
Lord.
Hey, Patham, you asked Mr. Gogoi to be.
Lordship, may I kindly take up the my affidavit now. In the IML, in the similar challenge has been earlier, and that, and in fact, this is the third time they have approached the Honorable Court with paragraph 5. There page number 42. The interlocutor begs to say that the applicant and that on earlier occasion similar challenge was before the Honorable Court. In case number Lordship. Yes. That was rejected. They are not a party in. I'll take your lordship. Yes, annexures B. They are the party, if lordship kindly see. Margarita Assets Limited. All of them are party. Lipuli, all of them from Tinsuki. Some GPSs are not there, but most of the challenge made in this writ petition of the Targeted Public Distribution System Control Order 2001, which the state is invoking to initiate a tender process for transportation of food articles from FCI godowns through private transporters. Notice in this case was issued on 8/7. In this occupied dismissed by upholding the validity of the aforesaid. So 7/11, 7/12. Then kindly come to page 66. Because in the meantime, the transporter was not allowed to allow the contract. It is very important on 30. 2 writ petitions were disposed of. Page 67, Malad. 6. By a separate order passed today, WPC number 0/2000. Then kindly come to page number 69. The writ petition by them. Petition. Petition number 6. Lipuli petitioners are there. This is important, Malad. The petition in PDS articles to retail as the public distribution of provisions has been made for distributions from FCI godown of the intermediaries and doorstep eligible of frequency to be there by transporters, carriers, contractors, planners, counsel for the petitioners. Contractors are alleged they should be liable for. However, no scheme has been made by the government so as to say carriers, contractors, the decision of the state government could cause loss. And so they order an appointment of the transporter carries 7 and 7/12 should be set aside. Number 6 of it. Decision of the state government with parties to of 2015 had also been which is the subject matter of 30/7/2018. He also submits that other prayer of the present with regard to the challenge made to the notice inviting tender for selection appointment Lordship. Look, here. Can you see the order? The order. This order, they have, they. The affidavit we have said. Tender process logical. Not to act, not to act upon. Till the returnable then. Therefore, there is happen, my lord, in our affidavit, we see. Para मतलब page 47 last paragraph मतलब page 47 it's a part of 6 2526 NIT has been issued 25 in the same manner like the previous years. However, the NIT dated so and so. Agencies.
Page 62, Your Lordship.
Yes, seven provision. Lordship. मतलब as in the concept. That is my respectful submission, my lord. That Lordship. When they, in fact, The lordship. Yes, that was the precise change. I have annexed the. Lordship, I have annexed the. Yes, Malagas is here. Yes, yes. Clause 8(3). Out. That is the state government that have exclusively vested with the and delivery of the food grains. So as to pursuing doorstep delivery of food grains to each of the obligation cast under section 24(2) of the. It will be significant to know that placed by the order of distinctively clear that accordingly by issuing the NIT, the respondent number sought to appoint transporters and transporting food. Under the order of 290. Section 2A of the order of 1982 provides that appointed dealers would be the cooperative society engaged in the business, sale and storage of sale. That the wholesale, the retailer would only right to sell the such notified by the government. Quotation of the PDS article code and generate any income further. It is not doubt true that clause 2Z envisages any private party in the. But what the respiratory the powers the role, therefore the of order of 9 to the coming to the next question pertaining to the interpretation of Z of the order of 2000. There can so there is a well, but as Does the statutory obligation delivery of the food grains from the designated ensure actual delivery of supply of food for B2B indicates part section 24(4) of the food grains. Therefore, if either there is nothing in the thing it from employing extra but my not Yes. But my respectful submission would be, Malad. The definition at along with 7-11 and 7-12. Those were not. The authorized agency has been considered with through the deputy. This judgment. Respectfully, sir. Court has, while considering this decision, my lord, while passing this decision, has also considered that the authorized agency so defines the definition of authorized agency has been said that it means the concerned department of state owned by cooperative has been considered, but at the same time, the honorable court has also said the honorable court has also considered yes, my lord. Yes, my lord. It is, but what do, it is the state government which is the repository and an authority for the PDS network. Therefore, the role of the lodging. One thing has to be considered. That if some they have eligibility. Clause below. That they all and ensure its proper distribution through the PD, yes, lies with this. Same breath, particular challenge, if private contractors were in the picture. Yes, government has taken that that particular scheme they have framed. Lordship. And allow them to transport. That is that. Because kindly, Lordship may kindly consider that what they cannot do directly, they cannot be allowed to do that indirect. My second submission is not. The Lordship. But that 1889, so it's a.
Essential commodity sectors.
But that is why, my lord, I am trying to. The balance of convenience and the irreparable loss. Right?
Cannot be a time.
What at that stage, because at that stage was So, my lord, the order at page number annexure that is there are some where tender processes have been issued and considering the status quo order, there are but this petitioner no, page number 69 was not, page number 69 of our IA. No, matlab, page number 69. Yes, yes. Lodge. Matlab, this particular, that is why matlab, the beginning, matlab, my main contention matlab, I have raised is that this is the specific they have brought in two other repetitions, those were negative. Page number 69, page number 69, and they were allowed that if you have any, you go, because constructive resolution specifically Honorable Court has said that you are barred to raise those because you are barred by constitution. So vis-a-vis whether the government has the power to factor or not. It was also there. It was also there, Bharat. But the he has been taken management of private contractors by the government scheme, my lord. The NFSA. They're transporters. And therefore. Citing the repetition. what I'm indicating. They have approached the grievances. By filing with that since lordship has stayed, we may be then we'll get the benefit. So, when two have been rejected. Is 70, is 70. My, if page 78, page, the earlier tender process has been challenged. That that is a relevant one. I'm not.
Pleasure, Lords. Very grateful, Your Lordship.
That's true. But done. But petitioner is that only case. The deciding the interim application, whether that interest of the interest, the larger interest, protect. Gotcha, gotcha.
What would be the reasonable time? Maybe 2 months. We will. You don't want to see persons for whom this is not getting late, maybe. Not what you will take this.
Since two. Here, there is nothing, Malad, there is nothing.
Deeply.
Because the entire day will help calculated manner. Need one here FR answer email. Here Malan FR 56 have been That my lord, and finally, same view was taken consider. The other case, my lord, have been given. Here also some discussions are made, my lord. It will have to be at least considered, not to give only consideration taken. Oh,
Much obliged, Lordship. Lordship. Much obliged, Lordship.
Pursuant to that, probably that OM has been issued. The justification they cannot provide. They know the OM, just they had one day. Here, my lord.